Well, thank you very much indeed for staying with us, and welcome to those of you who've joined. Particular welcome to the students from Batley School, with whom UK Changing Europe has a particular relationship, who are sitting at the back. This session is called Can and Should We Rein in the Judges? The Future of Judicial Review, a very live topic at the moment. With the Judicial Review Bill going through Parliament. I have with me four excellent panellists who I will briefly introduce. Brevity is an indication of their distinction rather than their lack of it, because you want to hear from them and not from me. I'm going to introduce them in the order that they are going to speak. So first of all, on my far left, Jonathan Jones KCE, who was the head of the Government Legal Service between 2014 and 2020. It will be recalled that he resigned over his government's proposals, or over the government's proposals, I should say, to put clauses in the Internal Market Bill which were allegedly contrary to the UK's obligations under public international law. Now, I always feel for him because, of course, by definition, he's always introduced in that way, that he's famous for resigning and not famous for the good things that he's done. He is now senior consultant at Linklaters and also the enjoyer of finer things in life, including cocktails and Ely Cathedral. And probably in that order. To my immediate left is Sir Stephen Laws KCE, served as first Parliamentary Counsel between 2006 and 2012. And for those of you who are less familiar with these things, he was responsible for drafting all legislation laid before Parliament, although presumably he had some people giving a bit of assistance. On my right is Alison Young, Sir David Williams Professor of Public Law, and it's harder to think of anyone more worthy of holding that title. And in my view, she knows more about public law than almost anyone I've ever met. She's a legal advisor to the Constitution Committee, and she is also my wonderful colleague at Cambridge. And then on my far right is Richard Ekins, Professor of Law and Constitutional Governance at Oxford and Fellow of St John's College. He's also head of the influential Policy Exchange Judicial Power Project. He's a New Zealander by birth, but we don't hold that against him. And he is also one of the nicest academics to walk the earth, and that admittedly doesn't often say very much about my colleagues in academia, but he is excellent. I'm delighted to welcome them all here. What we're going to do is each one is going to present for 5 minutes. We will then have a bit of a discussion on the panel, but again, I urge you to ask your questions on Slido as we did before. It doesn't bite, it's incredibly easy to use. Even I've managed to master trying to juggle iPad and bits of paper. So please do ask your questions. So, Sir Jonathan, the floor is yours.
Thank you very much, Catherine. Very good to be here and see real live people in front of me. Should we rein in the judges? As lawyers, there's a risk we spend half our time dissecting the question. Who are we, for a start? I think the question has been deliberately designed to be provocative, even shocking. Aren't judges supposed to be independent? Doesn't reining them in imply interfering with that independence? Certainly, Parliament can change the law, including in response to individual judgments, but surely the judges must be free to interpret and apply that law. Now, the first point is that we're here focusing on one particular aspect of the judge's role, admittedly a very important one. This is public or administrative law, judicial review, the law as it applies specifically to the acts of government and other public bodies, and that is obviously a vital element of the judge's role, but it's only one. Every day, the judges are also dispensing justice in thousands of other types of case: criminal cases, family cases, commercial, other private law disputes, employment cases, and so on, interpreting and applying statutory and common law. We trust the judges to decide those cases fairly, justly, and independently, don't we? Giving effect to the will of Parliament. Why do we think they need to be reined in when it comes to judicial review? One answer to that might be that judicial review cases are particularly likely to raise issues of policy, in inverted commas, where it's especially important for the judges to avoid rewriting the policy and stick to applying the law as enacted by Parliament. But whenever the judges apply statute law on family law or company law or whatever it may be, they are similarly giving effect to policy, invariably the policy of the government of the day, as enacted by Parliament. So why doesn't the same risk of judges straying into the policy space arise there? Now, the Independent Review of Administrative Law, or IRAL, concluded, to perhaps oversimplify, that there wasn't a major systemic problem. And to quote selectively, because I haven't got much time, it said this: while the panel understood the government's concerns about recent court defeats, the panel considers that disappointment with the outcome of a case is rarely sufficient reason to legislate more generally. In other words, Parliament can legislate to change the law in response to a particular case, but there wasn't a more general issue. Solutions to any potential problems of judicial overreach must come from the courts, and the courts should be encouraged to do what they can to address these problems. The most obvious solution to a potential problem of judicial overreach is judicial restraint. So IRAL itself made only relatively modest proposals for reform, including reversing the decision in CART, which we may come back to. And those proposals are, give or take, being taken forward in the Judicial Review and Courts Bill. But we should recognise that the IRAL report and those recommendations do not really reflect the strength of feeling on the part of government about judicial overreach. The Attorney General has been particularly critical. In her speech to the Public Law Project conference last October, she referred to a huge increase in political litigation, that's to say litigation seeking to use the court system and judicial review to achieve political ends. The Attorney General's language was quite punchy. While she said she was not intending to undermine the judges or their judgments, which are, of course, both entitled to the greatest respect, she said that the Supreme Court had wrongly stepped into matters of high policy. Its decision in Miller 2 was inapt. Its decision in Privacy International on the powers of the Investigatory Powers Tribunal, on the reviewability of the IPT, was profoundly troubling. Its reasoning in Adams, on the extent, but partly on the extent to which ministers' functions could be delegated to civil servants, was deeply strained, if not implausible. And the Lord Chancellor, Dominic Raab, has weighed in also talking about decisions of the courts harpooning major policy decisions. So some fairly punchy criticism from government. What's the response of the courts been? Are they backing off as a result of this criticism? Some have thought so, maybe. Robert Buckland, in his remark, referred to the case of SC. The Attorney General herself welcomed that decision, which seemed to her to assert a more traditional approach to judicial review. She particularly liked the passage where Lord Reid observed the need for the courts to apply the principle of proportionality in a manner which respects the boundaries between legality and the political process. We've seen a recent judgment of the Divisional Court in the Good Law Project and the Runnymede Trust case, adopting a relatively restrictive approach to the question of standing in judicial review, and that, you can see, might well help to allay the government's concerns over political litigation. So maybe there has been a change of tone. I think it's probably too soon to say that there has been a more pro-government trend. And anyway, there will always be cases going both ways, and we've certainly seen cases of the government losing and being criticised by the courts, including the other day the MA and KH case on the seizure of mobile phones from migrants arriving in small boats from France. I mean, in that case, very significant concessions of illegality were made by the Home Office, but the court found against the Home Secretary on other grounds, and there's not much sign there of the court holding back. That's the end of my time, really. In conclusion, though, I have some problems with the question, and I'm uneasy about who the us is who might be telling the judges what to do or what not to do. The government, obviously, or at least part of it, does think that the court should be reined in, although perhaps only in the area of judicial review, where the government's own conduct is in play, and that makes me a bit suspicious. The judicial review in Courts Bill as it stands doesn't actually go very far to achieve that, so maybe the government would like to go further. IRAL didn't really see a significant problem. It thought the best solution to judicial overreach, if that's what we've seen, is judicial restraint, and maybe that's what we are now seeing.
Okay, thank you very much, and thank you very much for providing a model for any students as to how to answer or not answer the question in the specified period of time. I turn now to Stephen Laws.
Thank you, Catherine. Former US Supreme Court Justice Learned Hand defined the spirit of moderation as follows: the temper which does not press a partisan advantage to its bitter end, which can understand and will respect the other side, which feels a unity between all citizens, real and not the factious product of propaganda, which recognises their common fate and their common aspirations. And he said this of it: this much I think I do know, that a society so riven that the spirit of moderation is gone, no court can save, that a society where that spirit flourishes, no court need save, that in a society which evades its responsibility by thrusting upon the courts the nurture of that spirit in the end will perish. That more or less sums up what I want to say on this subject.
Stop now.
No, I'm going on. Involving the courts in issues that are more suitable for resolution in Parliament by democratic political processes has grown and is growing. Developments affecting JR proceedings have been a large part of that. Resolving political issues in the courts provides definitive winner-takes-all solutions. It's the possibility of total victory that creates an obstacle to compromise and to political consensus. That's what threatens the spirit of moderation by disrupting and displacing the operations of the mechanisms of what Robert Button said was our political constitution that support it. And those mechanisms, I think, work. Today's question is, I was going to say tendentious, Jonathan said provocative. I do not think that our judges are unruly horses who need to be reined in, nor do I think that they are horses who have bolted so that they cannot be reined in, that there is no point in closing the stable door. If Parliament so chooses, of course we can, as a society, can rebalance the respective influences of politics and law on our national affairs. Our judges are duty-bound to respect parliamentary sovereignty, and it would be foolish to suggest they might not, and disrespectful. But should we rebalance? I'm one of those who think we should. It's a question that is itself also a political question. It's a mistake to think the politics in it can be neutralised by legal or academic analysis. Law has different political and forensic objectives that are often in tension and compete. The correct balance between them is a political choice. Should the priority for the law be meeting the desire of the vast majority of us to be able to organise and conduct our lives in compliance with the law, but without becoming involved in legal disputes? Do we want the law to continue to be an effective tool for producing democratically legitimised social change? These are the characteristics of legislation. Or should the priority instead be a retrospective concentration on the outcome in individual cases? Should the quality of the law, including the law relating to judicial review, be tested primarily by reference to how it works forensically for resolving legal disputes as they arise, or how it impacts on society more widely? Legal disputes represent only the tip of the iceberg so far as law's practical impact on society is concerned. Litigation tends inevitably to be confined to rare, often atypical situations at the edges of what the law allows or requires. And as we all know, hard cases make bad law. I think an imbalance between these approaches has developed and requires a readjustment to protect the effectiveness of legislation as a means of influencing future conduct and implementing social change. The developments in judicial review jurisdiction have contributed to the imbalance. A very significant factor in that has involved the application by the courts to legislation of principles and remedies that are suitable for use only in dispute resolution and casework. For failing properly to respect the distinction between the different contexts of legislation on the one hand and dispute resolution and casework has resulted in the importance of legal certainty and predictability being dangerously undervalued. This manifests itself particularly, and Robert Buckland addressed this, when unequivocal legislative specifics are allowed to be qualified with vague general principles, such as those provided by the ECHR, the so-called principles of legality. I'm in favour of more specificity and granularity, as Robert Buckland was. Legal certainty and predictability are very important components for the rule of law, as Robert Buckland also said. They are needed for dispute resolution, but they are absolutely essential when legislating. No litigant should have to litigate a dispute up to the Supreme Court to find out how the law applies to it. Even more important, though, is that the law relied on by ordinary citizens for planning their future conduct is clear from the start and can be relied on without the need for litigation at all. It's more damaging still if those in government and parliament who make the law are themselves unable confidently to predict how the law they make will be applied in practice, and whether the political compromises that produced it will be allowed to stick. But that, like it or not, is where we are as a result partly of developments in the judicial review jurisdiction. In too many cases, there's now a risk that a litigation stage will be needed before new law can be relied on, and the desire to mitigate that risk can have crippling effect on sensible policy formulation. If it's made impossible for you to guarantee the effect of the law you make, there is no point in taking responsibility either for producing legal certainty or for securing that the law conforms to any relevant general principles. Instead, your best option, and I've seen it done, is to make it vague enough for the courts to do what they feel they need to do with it, or maybe just not to bother with accepting the risks of initiating a change at all, even if change is vitally necessary. If the ultimate responsibility for the substance of new law and for the extent to which the legal status quo can be allowed to change belongs to the courts, not politicians, irresponsible politics is the inevitable and logical result, and so is damage to the reputation of the judiciary for political impartiality. Moreover, it's the availability of the option to make predictable changes to the law that's a large part of what mandates public sector conformity to the existing law till it's legitimately changed. We have a long-standing culture of principled legal compliance in the UK public sector, of which I'm very proud. Those who make the law conscientiously adhere to it because they, above all, can be expected to know exactly what it means. Invalidating that premise leads inexorably to the replacement of a principle-based approach to legal compliance with a risk-based approach. This is understandable, but it's not a development to be welcomed, and it is all too easy to see happening. So it is that thrusting the nurture of the spirit of moderation on the courts causes it to perish. The growth of judicial review and its extension further into politics is often justified by those who mistrust or have despaired of our political culture. They think our politics needs tighter regulation. I think our political culture is strong, and I believe their concerns are misconceived, or at best wildly exaggerated. More seriously, I think it is obvious that attempts to extend the legal regulation of politics, for which JR has become the established mechanism, only aggravates the mischief they think it can remedy.
Thank you very much indeed for those very thoughtful remarks. Can I turn now to Alison?
Thank you. Thank you, Catherine, and thank you so much for your kind words and for inviting me. So, as a good academic who spends her time telling students how to answer questions, can we rein in the judges? Well, the simple answer would appear to be Parliament is sovereign, Parliament can do what it wants, so of course it can. I think that's too simplistic, and I think we have to understand that parliamentary sovereignty has to be balanced against other principles, like the rule of law and the separation of powers. And also remember that judicial review also shores up parliamentary sovereignty, doesn't necessarily undermine it. In terms of should, I think I'm concerned that there's a danger of overreacting to a series of cases taken in extraordinary times, and we forget just how much we have a general element of case law, as Jonathan has already said, beyond judicial review, and a general element of case law and judicial review that often shores up the will of Parliament. So in order to try and explain why I don't think the answer is simply Parliament can do what it wants, I want to talk a little bit about ouster clauses. So for those of you who are not used to judicial review speech, an ouster clause is a clause that says the courts cannot review a particular decision of the executive or the administration. And we have dicta in a recent case from Privacy International from Lord Carnworth that tells us that binding effect could not be given to a clause that was removing judicial review for excess or abuse of jurisdiction or error of law. Lovely legal speech, but what's he trying to get across? Well, what he's trying to say in that particular case is sometimes Parliament says, here is a tribunal or an executive body that has limited powers. But what we're going to do is say it can determine what those powers are and the courts can't check it. That's a little bit like me saying to my teenage daughter, you have a curfew, but you can tell me what the time is of your curfew and you can check whether you've met it or not. She's bright enough to realise that's not her curfew. But also I think we have to recognise if Parliament is saying on the one hand, here are bodies with restricted powers, it can't on the other hand say, oh, and by the way, they can determine the scope of their powers and no one can check to see if they've gone beyond them. And if Parliament has given them those powers, then isn't it the job of the courts to check that these bodies have not gone beyond the powers Parliament has given them? And as we can see in cases like the Dissolution and Calling of Parliament Act and the Judicial Review and Courts Bill, which is still going through Parliaments, ouster clauses can work in specific situations when they are not going to undermine parliamentary sovereignty or undermine the rule of law. The first looking at a contestable issue as to whether checking the dissolution of Parliament is a legal or political issue, and the second one giving limited judicial review over the upper tribunal when it decides not to hear cases or hear appeals from cases of a lower tribunal. What about should? Well, I think the other thing we need to think about in terms of should is sometimes it's quite tempting to play what I've decided is judicial review top trumps. Let's go away and find a series of cases that seem to conclusively prove a point for us. Now, the problem is everybody wants the Miller case, when we had to decide whether the government could trigger the process to leave the EU or whether you needed legislation, and the Miller-Cherry case on the prorogation of Parliament in their deck. Because if you think judges are going too far, you'll immediately say this is the epitome of the judiciary going too far because this was a political decision. If you think this is an example of the judges not going too far, you'll look at the case and say, but what did the courts actually do? Well, they preserved the sovereignty of Parliament and they tried to ensure that the government was held to account by Parliament and Parliament in turn is held to account by the people. Now, I notice that they're scribbling away. But my point I'm trying to explain to you is we can use these cases to make both points. Why? Because we're arguing about a contestable issue. What should the powers of the courts be? And my concern is if we focus too much on specific cases, then we have a problem because we have selection bias. Let's choose the cases that are most likely to make the point for us and forget the vast bulk of cases that might actually be shoring up parliamentary sovereignty. Second, I think often we misunderstand the precise context of what is going on. There are important pieces of legislation in both the Miller case and the Miller-Cherry case. We've also heard mention of Ziegler and Elan Kane, other cases we like to rule out and play. These are very specific cases with specific pieces of legislation that need to be understood in their particular context. So you can't just play them to make generalisations and general arguments. Also, when you're looking at cases like Miller and Cherry, and this is my third point, your problem you've got there is you've got a unique constitutional controversial issue. And I think we need to recognise that in a lot of these cases, when we have diversive issues, often when you're thinking about politics, you're thinking mostly about ends. And sometimes that means you don't necessarily check the means. The nice thing about the courts is they're also there to check the means. How are you doing this? Are you doing this in a way that would undermine the sovereignty of Parliament or undermine some of our constitutional fundamentals? Do I think there are easy answers to whether we can and should rein in the courts? No. Do I think we should rein in the courts? Also, no. Because I think when we take a step back and understand what the court was doing in these controversial cases and put them in their context about what courts are doing on a day-to-day basis, I think we'll find that the courts are there to shore up fundamental principles of our constitution and also, in a lot of circumstances, to shore up the sovereignty of Parliament itself.
Thank you very much indeed. And finally, may I turn now to Professor Richard Ekins.
Well, thank you, Catherine. I'm grateful to you, Catherine, and your colleagues for the opportunity to speak today. I plan to say a little bit about judicial review reform in general and then turn to the detail of legislating about judicial review in particular. And then I'll finish by touching on a point some others have, which is the new direction the Supreme Court seems to be taking under Lord Reid's leadership. The first point to make, I think, in any discussion about the future of judicial review reform is that judicial review is an indispensable part of our constitution and should be valued accordingly. But the question for present purposes, I think, is where the law should set the limits of judicial review. Put another way, does the law of judicial review permit or require courts to answer some questions and to consider the exercise of some powers that should not be the subject of litigation, deploying grounds of judicial review that involve taking over aspects of government or second-guessing Parliament? And does such litigation distort parliamentary government? These are perfectly fair questions to ask about the law of judicial review as it's developed over time. They're also questions routinely asked in different ways within the legal profession and the academy. They are too important, I suggest, to be left to lawyers alone. Ordinary people, so to speak, non-lawyers, and their elected representatives are entitled to think about the changing scope of judicial power and act to correct it. My own view is no secret. I think the traditional limits on judicial review need to be restated. And I do make much of some of the leading cases in the last decade or more, where one can see, I think, judicial review proceedings extending too far, addressing questions that should not be for courts, displacing the law Parliament has made, or the political dynamics that should discipline how public power is exercised. And quite apart from particular cases, as Stephen has noted, I think there are reasons to worry about the impact of overly intrusive judicial review on policy making and legislating more broadly. Like Stephen, I take parliamentary sovereignty to mean that Parliament can oust judicial review and is free to legislate to restore traditional limits on the jurisdiction of the courts. That may be Jonathan's position too. Alison's touched already on Privacy International, and I would like also to stress the fact that 3 judges out of the 7 in that case questioned the proposition that Parliament could oust judicial review. They speculated about a future case in which judges might openly refuse to give effect to legislation. Now, I very much doubt whether a future court, let alone the present Supreme Court, will ever act in that way. And if it did, it would be breaching unconstitutionally fundamental legal proposition. So I think Parliament should proceed on the basis that it has authority to change the law of judicial review. That said, there are some very good practical reasons to avoid codifying the law of judicial review. The better technique may be to make targeted changes, responding to particular problems in the law of judicial review in ways that may encourage wider judicial self-discipline. The Dissolution and Calling of Parliament Act, which Alison's just mentioned, enacted just last week, makes one such targeted change, protecting the newly restored prerogative of dissolution from judicial review. The Judicial Review and Courts Bill, back in the House of Lords on Thursday, makes 2 other changes, as noted. The bill is a limited measure, clearly, making only modest changes to the law of judicial review. In a policy exchange paper last year and in evidence to Parliament, I've suggested some other changes Parliament might usefully consider, including reversing the Supreme Court's Adams judgment and restoring the Carl Toner doctrine, which is fundamental to how our government works, legislating to overrule the private international judgment and make clear the primacy of legislative intent in statutory interpretation. Legislating to overrule the prospective effect of the Supreme Court's prorogation judgment, specifying that neither parliamentary accountability nor the political constitution are justiciable. Limiting judicial review of the exercise of the power to set tribunal fees, restoring the ministerial override in the Freedom of Information Act 2000, which the Supreme Court undercut in its Ekins judgment, limiting judicial review in relation to ombudsmen, inquiries and devolved legislatures, imposing limits on how evidence is handled in judicial review proceedings, and limiting the judicial discretion to permit interveners in judicial review proceedings. These are not radical changes, I suggest. Each would restore the law as it stood until fairly recently. It's possible some of these ideas may be taken up in a later bill. In the meantime, the present bill is clearly modest, but I don't think it's unimportant. It confirms Parliament is willing to legislate in this domain and willing to overturn particular leading judgments. Well, the future of judicial review will turn in large part on developments in judicial culture more widely. And what will be key is how future judges and lawyers think about the capacities of courts, about the political constitution and its adequacy, and about the merits of the traditional limits. It's early days, but I think the Supreme Court, under Lord Reid's leadership, is charting a different course, or it does at least seem to be, to that which was taken under Lady Hale or Lord Neuberger. And you've heard some of these cases mentioned before, but I think in the human rights context, the AB and SC judgments are important, and Elin Kane and Rein McQuillan, both handed down just before Christmas last year, are important likewise. And in relation to ordinary judicial review, so to speak, the Supreme Court's unanimous Begum judgment, Shamima Begum, seems very important to me as well. I think it remains to be seen whether the expansion of the principle of legality that's been seen in some cases in recent years will continue under this court, and relatedly, whether the approach taken in the prorogation judgment in 2019 will be applied in other contexts. If there has been a change in disposition, the explanation may lie in the fact there's been very considerable change in the personnel of the court and the court's membership, and also in the political context in which the court's now operating. Now, I don't mean by that to echo Jolyon-Morn's accusation in late 2019 that the judges were all set to be cowed by the new electoral majority. If that's the case, we have a serious problem with judicial independence, and I don't think we do. What I mean is that the 2019 election and the subsequent withdrawal from the EU lowered the political temperature, showed, I think, the political constitution working effectively, whatever you think of the decisions. The court is no doubt aware its judgments might now be overturned by legislation. I think that should encourage it to hew close to settled law and avoid making constitution-making judgments that it has no legal authority for. But the new court, I think, seems in any case to have decided that some recent case law has gone too far and is in need of correction, which is a development to welcome. Now, having said that, there are, of course, limits to the court's capacity, to any court's capacity, to correct past mistakes. But overall, I'm encouraged by the apparent new disposition of our highest court. And taken together with targeted legislation to restore traditional limits, I think the future looks promising. Thank you. Thank
you very much indeed. There's been some tremendous questions coming in, and I thought rather than the panel respond to each other straight away, I thought we'd engage with the questions, and then I'll give you a chance to comment and wrap up before the end. So just to remind you, please send your questions via Slido. And for those of you not familiar with Slido, you can vote on the most popular question. And by far the most popular question that's come in so far is from Paul Evans, who says, does Parliament need the judges' help to rein in an executive which lacks respect for the principles of moderation and parliamentary sovereignty? And I might put that, start with you, Richard.
I don't think, with respect, that the government or governments I can think of have a lack of respect for parliamentary sovereignty. And I know that the prorogation judgment, Alison mentioned it, was a sort of instance where parliamentary sovereignty needed to be protected against the government. I don't read the case that way, or the scenario, the episode, in that way. And I think parliamentary sovereignty is being, I've been defending it for my entire legal career, but I think it's being given an expansive reading in order to leverage a kind of judicial intervention that otherwise isn't justified. And I think you see that in the prorogation case, you see it in some other cases too. So I am worried about that. I think it's a weaponising of the idea of parliamentary sovereignty, going beyond its traditional scope in order to licence new interventions. Moderation, well, the government's moderation or lack thereof is entirely rightly a question of political controversy, and the court can do its bit to ensure moderate disciplined government by upholding the law when appropriate. The case Jonathan mentioned of the seizure of mobile phones, I confess to not having read yet, seeing it's important, but it's on my to-do list for later, and that may well be a case where the court has quite rightly corrected a widespread unlawful practice, and in so doing it does its job. But I don't think there's a general problem with the government having a contempt for the spirit of moderation, to echo Stephen, or for parliamentary sovereignty.
Jonathan, can I turn that question to you, given that you obviously were concerned about the use of parliamentary sovereignty over the Internal Market Bill?
Yes, and perhaps I should always say thank you for introducing me. I'm going slightly beyond that I'm the lawyer who resigned. The other thing I should always say on these occasions is that as Treasury Solicitor, I did act for the government in most of the cases we're talking about. Just standing back a bit, my answer to that question would be the risk of us all agreeing a bit too much. This idea of weaponising has been said. I agree that's not a helpful way of looking at it. The three branches of the state, the courts, the executive and Parliament, have got to find a way of muddling along together, and they do to that extent support one another. And yes, when the executive oversteps the mark, but by that I think we're all saying legally abuses its powers in an unlawful way, including the very many powers to make secondary legislation that Robert Buckland touched on, then it's the role of the courts to check that and apply the limits as set by Parliament. So this kind of symbiosis, that's a sign of the Constitution working correctly. On the Internal Market Bill, I mean, it's quite a specific point that I've talked about ad nauseum elsewhere, that I think the executive did overstep the mark by inviting Parliament, as Parliament undoubtedly could have done in its sovereignty, to legislate in a way that breached its international law obligations, and I regretted that, and that's why I resigned. But it's to be expected that the courts would have given effect to the legislation enacted by Parliament if Parliament had passed that bill. So I don't think we could have expected the courts then to correct what I thought to be that unfortunate act contrary to international law. So maybe that's a rabbit hole we shouldn't go any further down. But my overall point is that the spirit of sort of comity that we've talked about, Robert Buckland mentioned, is, I think, at the heart of quite a lot of what we're saying.
Thank you. I just want to feed in Meg Russell's question there, which touches upon the point you've just made. And she says, as Robert Buckland hinted, might the primary fault lie with politicians? Do ministers and Parliament too often dodge difficult topics, thereby kicking them to the courts? Stephen, obviously your experience was somewhat before this government, but do you want to comment on that?
Yeah, I do, because I think there is a dynamic in politics that politicians find often that they want to pass responsibility for things they think they can't properly control to other people. And you see it with the way quangos are set up to manage various bits of government. But there's a cycle to that, because after a while, ministers find that they're being blamed anyway for what the person they've delegated it to do, so they want to bring it back in. And I think there's an element of that in that some very difficult questions have been delegated to the courts. And the courts have taken on that delegation, I think sometimes more enthusiastically than they should have done, but they've taken it on board, and the cycle proceeds, and government thinks it needs to bring them back in because it's going to be held responsible for what happens anyway. So, short answer, yes.
Thank you, Meg. Alison, do you want to comment on either aspect of those questions?
I think we're constantly going back to comity, and I think that's important. I think it's also important to recognise what the different functions are of the different institutions in government. And I think, as I keep repeating, you have to think very, very carefully about context and specifics and not just draw generalisations from these big cases. And I think Richard is absolutely right to recognise that when we're talking about big cases like the prorogation case, you were talking at a very difficult constitutional situation, and I think it's one of those areas where you can blow that out of context. I don't think that was a case where they were weaponising parliamentary sovereignty. I also don't think it's a case where there's a misreading of parliamentary sovereignty. I think we have to think and ask ourselves, why do we want Parliament to be sovereign? Well, because it's a democratically elected body. And that's Parliament that is the democratically elected body. We draw a government from out of Parliament, but the government is indirectly elected, and we need both political and legal checks over a government of whatever political persuasion. When we're thinking about this idea of comity and protection, I think we have to recognise that the courts are there to look at these long-standing principles. They can recognise when legislation might have been enacted that has missed how this might have an impact on a long-standing principle. They can also recognise when general legislation might be applied to an individual in a way that undermines rights, and they can recognise when the government has gone beyond the powers set out in legislation. I think that's an important function of the court. It's not what parliamentarians are there to do, and we need the courts to go away and check those decisions.
Thank you. There's some feedback on the line which they're just trying to fix. Come a bit further forward, because I think the issue is that we're talking too quietly rather than too loudly, and they've had to adapt. Richard, I want to just add in Trevor Taylor's question. Were Miller, I mean, obviously you focus on the Miller 1 and 2 judgments as one of the number that you think the courts got wrong. I oversimplify. But Trevor Taylor says, look, we've got to look at the context. They were extraordinary circumstances, and do they really need to be counteracted, as they didn't frustrate Parliament? Quite the contrary. They actually put power back into the hands of Parliament.
Well, extraordinary context, it's true for both of them. And I don't anticipate, especially given the parliamentary numbers have changed so sharply, that we'll see a repeat anytime soon. And the Supreme Court in the second judgment tries to say this is a used bus ticket, this judgment. It's good for one trip only. Don't come back. A court cannot control the reception of its judgment in that way. And it's a unanimous judgment of the Supreme Court that makes some bold claims about constitutional principle. I think expands them in ways that really do open up possibilities for much more sweeping litigation in the future. And the concern about weaponising parliamentary sovereignty, I have to say, is not just mine. It was shared pretty expressly by the Divisional Court, a very strong court of the Lord Chief Justice, Master of the Rolls, President of the Queen's Bench Division, in resisting the invitation to review the lawfulness of the prorogation. So, I mean, everything here turns in a way, and Alison's right, you've got to read the cases carefully, of course, and figure out what's decided, what the context is, what they stand for, what their implications are for what follows. I think I've done that work. I might be wrong, but I've suggested here are the problems, the discrete problems that arise, and here's why they warrant an answer. And the thought, I mean, I see this a lot, I think, which is, well, where's the foul, given that these just empower Parliament in some way? Well, I think they displace the balance between our institutions, which we're all concerned with, the traditional balance that's well established in law. And if you're willing as a court to modify the legal bounds that apply without acknowledging it, which they very clearly did in the second judgment, I think the first Miller judgment is much more arguable, actually. I think it's wrong, but arguable. If you do that, then you do undercut the confidence that people have in the law being applied faithfully in difficult circumstances. No question, it was a hard and unpleasant political context, the crisis of a kind. And that's, I think, where you really got to have the court saying, well, we're going to stick very, very precisely to our remit. And I don't think they did in that case. I hope if it came again, they would do otherwise, but we'll see.
Stephen, you want to come in?
Well, I wanted to come in very strongly to agree with what Richard was saying about the impact of the decision, because it's very easy to discuss all these decisions on the basis, was this a good decision or was it a bad decision? But what is important is its impact on how people see the courts operating. Do they see the courts coming to a decision which more or less the whole world thought the government was going to win in Miller 2? Lord Sumption, although he subsequently supported the decision, predicted beforehand that the government was going to win. People see the law not being applied as everybody expects it to be applied, and that goes right across the board. If you don't know what the law is going to be, you don't know how to behave. And I have to get on my hobby horse about whether Miller 2 was supporting parliamentary sovereignty or not. 4 weeks before the Miller 2 decision, Parliament had passed an Act of Parliament that set out specifically the days during the autumn of 2019 when Parliament could sit and not be prorogued. The government undertook a prorogation that conscientiously complied with those dates. The Supreme Court seemed to think that was a coincidence, but I prefer to think it wasn't a coincidence. What government was doing was complying with the Act of Parliament that set out when Parliament should sit during the autumn of 2019. And what the Supreme Court came along and said was, what Parliament decided about this is not good enough. We're going to impose extra restrictions on when Parliament can sit during the autumn of 2019. And that doesn't seem to me to be supporting parliamentary sovereignty. It seems to me to be showing contempt for it.
I have another question that's come in for you, well, it's for the panel, but I think it touches upon particularly some of the points that you were raising. And it's from Alexander Horn, who says, organisations like the GLP, the Good Law Project, have used crowdfunding to pursue what might be seen as political litigation. Is this an area in need of reform? And I should just say, he adds as a second follow-up question, is there a risk that the use of crowdfunding promotes popular rather than meritorious litigation, or is it just a consequence of restrictions on legal aid? Do you want to start? Yeah.
Well, I think the way to reform it is to make sure that political litigation, that the law does not allow for political litigation, that the issues that are political are left to be resolved by politics. I don't think you should control how people provide funds for litigation. You should provide what remedies are available from the courts, and they shouldn't be remedies that provide political benefits rather than remedies to the people that are actually harmed by the conduct in question.
Do you want to go next, Alison, and then Jonathan?
Okay. I think we have to understand what you mean by political. Do you mean political in the sense of I was politically motivated to bring the case? Well, what does that mean? Am I politically motivated because I think this decision was wrong and I want to change it? Probably, but that means I just don't agree with the decision. And if I agreed with it, I wouldn't bring judicial review anyway. Do I mean there could be political consequences? Well, again, we're talking about judicial review. This is a lot of decisions that are controversial and will have political consequences because we're challenging decisions of governmental bodies. I think what we're getting at here is, why is there crowdfunding in the first place? Is there crowdfunding because there isn't enough money in legal aid for individuals to bring cases, in which case we need to think carefully about how we fund legal aid? The other element about crowdfunding that I think is legitimate that we need to take a thought about is, how do we decide which of these cases are the ones that get to court? And should there be some kind of filtering system and some awareness of those who are putting money forward for these cases, of which ones have a strong legal claim and which ones don't have a strong legal claim? And there could be a justification for a filter there. But I think a lot of what goes on actually goes on at the filtering stage in the courts themselves. They're looking for a legal argument. The argument, I didn't like this decision, isn't going to get you very far in a judicial review case. The argument, here is a legal error, and this is why there is a legal error, is what the courts are looking for. And I think that is a good way of trying to filter out purely politically motivated. And as Lord Reid points out in the SC case, they are aware of these aspects of two bites of the cherry cases, and they do think very, very carefully about judicial review in those cases.
Jonathan.
Well, again, boringly, I'm going to agree with much of what both Alison and Stephen have said, but I'll put it the other way around. Most people, when they bring a judicial review, don't do it purely because they think the decision is unlawful. They bring the case because they don't like the decision and its effect on them or their business or their freedoms or whatever it is. But it's right that for that case to get anywhere, they should show that the decision was wrong legally, and that's the job of the court. The job of the court, we would all agree, is not actually to assess its own view of the merits of the policy or the underlying politics, but to determine whether the decision was unlawful. But that doesn't that doesn't mean that the motivation of the person bringing the challenge may be about the policy, maybe about the substance of the policy or its effect on them. And that's a fact of life. But it's important to keep those two elements distinct. Like others, I'm less fussed about the basis on which cases are funded. I'm more fussed about the tests that are applied in deciding them, and indeed the test to be applied in whether they're allowed to go forward or not. And then you're into the question of what the test for permission should be, and the test for standing, which, as I mentioned, has apparently recently been tightened up in one of the cases involving the Good Law Project. So that would be a way of ensuring that cases don't get to court where they are purely political and where there isn't an arguable legal point. But final point on this, from time to time the government, any government, does complain about the volume of unmeritorious cases and the need to weed them out. But the truth is, for any organisation dealing with whingers and unmeritorious complaints and allegations is just a fact of life. And there will always be cases of that kind. And you do need some kind of fair system for deciding which ones are, in fact, unmeritorious or vexatious. And it can't just be for the government to decide that we're just not going to deal with cases from, say, a particular category of claimant or whatever. So even for weeding out the purely political, unmeritorious, groundless cases, you need some kind of threshold, and that threshold ultimately has to be a legal one. There has to be some kind of legal test.
Thank you. I'd like to move on to...
Can I
go ahead, Richard.
I will disagree and say I think, I mean, obviously what political litigation is extremely important, but I want to touch on the crowd funding point, which Alex raised in his question. And I'm not an expert in how one would reform or regulate this sort of thing, but I think there are pretty good reasons for concern. Because sums of money are being raised to pursue litigation where the attraction is pitched quite clearly as certain political objectives will be accomplished. Obviously, there are lawyers involved. They make arguments that have a legal form, of course. Some of them are more or less plausible than others. But there are reasons to worry, I think, without going into any particular claim, that exaggerated claims are being made to the public about what can be achieved by way of litigation. That once the money is raised, you're going to keep spending it. So, of course, you're going to pursue appeals and carry on. Even in some cases where the prospects really are extremely low and should be extremely low. And I think this is a problem in terms of the way legal professions relating to the public and a problem in terms of the public representation of litigation. And Jonathan's touched on the standing cases recently. And if the Good Law Project has made a contribution to the law of standing, then hurrah. But it wasn't the point of the exercise, clearly. Now, as I say, I have no proposal for how one would regulate crowdfunding, but I think there are many barristers, clearly, and Alex may be one of them, who have concerns about this mode of the legal profession relating to the public. And I think you end up with a problem. You don't have the discipline of having a client. The client is a zombie. It's going to carry on regardless, and it doesn't exercise proper control over its lawyers. So I am concerned.
Thank you. The word comity has been used a lot. Actually, I'm going to start with Alison. One, could you briefly explain it for the benefit of those who are not lawyers? And secondly, there are two questions that have come in about comity, which are broadly the same. One from Pravar Petka saying, we talk about comity as a desirable account of the relationships between Parliament, courts and the executive, but does it reflect real practice? And the other one has just disappeared, but it was on the similar lines. Is it actually working practice? Can it be strengthened?
Okay, thank you. Comity. I'll try and not give you a PhD thesis on comity. What we're talking about, in a sense, is interinstitutional respect. So it's about each institution understanding its own proper constitutional role, being aware of the constitutional role of others, and trying to respect the boundaries in some sense. And the reason we refer to comity so often is because of the uncodified UK constitution. We don't have a system that says, here is Parliament, here are its precise powers, here are the courts, here are their precise powers. A lot of these are worked out through the way in which they interact with each other, and that's why comity, this idea of interinstitutional respect, is so important. And a lot of what we're talking about when we're thinking about are the boundaries in the right place, should we rein the judges in, is about understanding whether we think these institutions are no longer respecting their particular boundaries. Do I think at the moment there's respect for the boundaries? I think for the most part, yes. We can all point to specific examples where we don't think they are working. So a recent one from the Supreme Court decision a couple of weeks ago in a case called Craig, which Sir Stephen and I, I'm sure, will disagree on to some extent, was the ins and outs of what happens if a court makes a declaratory judgment. So it declares what the law is, but it wouldn't necessarily say, and that means you then have to do something. And this was a case declaring that not commencing a piece of legislation in Scotland, so bringing it into force, was unlawful, but it didn't force the government to do so. Then a problem arose because a couple of years passed before this came into force, and there was a statement from Lord Reid that we expect in those situations that the government will respect, and that's an element of comity. It's about respecting the different institutions. We expect these institutions to act in a way that respects other areas. There are blips, but I think for the most part, institutions are aware of their limits. And I think where we get these problems at the moment is because we've just come out of a very difficult set of circumstances in the UK Constitution that were normal circumstances, and were not normal circumstances, sorry, and that's why we're constantly asking, has comity broken down in some sense?
Thank you. Does anyone else want to comment?
Well, I have long experience of politicians being very unhappy with the courts and about losing cases. And this is well documented in the IRL report that it's a very, very common thing for ministers to sound off about the fact they've lost a case, and in one sense, why wouldn't they? If their particular policy or decision's been overturned, they're not going to be happy. Sometimes that spills over into very public criticism of the judges, and sometimes that goes too far. But normally, sanity, intervenes and prevails. What we've seen more recently, slightly unusually, is some of the criticism coming from Lord Chancellors and law officers, the sort of public criticism, including and perfectly polite, but quite trenchant criticism of the kind that I quoted from. That's a bit unusual, but such criticism is not unknown. If it goes too far, and I don't think it has, like others, I think there are some tensions in the air, but that's not unusual. If it goes too far, that is a bad thing, because if either the suspicion is that the courts are out of control and are making stuff up, that's not good for anybody's confidence in the independence of the judiciary or the proper functioning of the legal system. If, on the other hand, it is thought that as a result of this row between government and the courts, the judges are backing down and are being cowed, and I don't think they are, but if we were to reach that point, then that's bad too, because that suggests the judges aren't truly independent either. So that's why we keep coming back to this idea of kind of balance and a kind of that comity is the word, and that's why it's important we try and stick to it.
Thank you. Do you want to, and also there's a question which is incredibly popular on here, so I'll give you a chance. There's two. There's one which you're going to love, which we'll finish with, but another one which is that essentially, are we giving in to elected dictatorship if we defang the courts? Defang. To weaken, if we weaken the courts, yeah. John Denham says the balance of power moves back towards Parliament. Does this inevitably mean weakening protections against elective dictatorship?
I've never believed in the elective dictatorship. Lord Hailsham, it's almost 50 years, I suppose, since we started hearing about the elective dictatorship, and I've never believed it. I think parliamentary democracy does actually work, and the idea of an elective dictatorship is just the I think Jonathan used the word whinging of people who find that democracy doesn't give them the results they want.
Use it in that context, Stephen.
I did want to say something, though, about this idea that the courts should be changing things back if they've gone too far. and that they shouldn't be cowed. I mean, I take a rather purist view of this. I think once the law has been established in the courts should stick to it. I don't think that they should regard it as their responsibility to put things right that they've done wrong. I think if you reach a situation where that's the right thing to do, and there's a lot of argument at the moment that it is the right thing to do, you get to some very nasty questions about judicial appointments. Because if the answer to getting the law right is to get the judges right, then you're in a very different sort of context than you are at the moment, where if all the judges have to do is apply the law and it's obvious what it is, then it doesn't really matter so long as they're good lawyers who is appointed.
Okay, thank you. Richard, you want to add
yes,
something?
Thank you, Catherine. So I agree with Stephen about the idea of the elected dictatorship, which is a sort of recurring trope in public discourse, but amongst lawyers in particular, who often, or at least some lawyers, have a deep lack of confidence in the political constitution. And I think that does bubble up, not just through the long Brexit saga, but before that. If you think that Parliament's simply not up to the job of controlling the government, then you might think it's your job to compensate. Now, you might not think that. You might think, well, Parliament should just pull its socks up and get on with the job. But that view about the political constitution as dysfunctional, as failing, as we're one step away from disaster at every stage. Thank God the courts can stop the government from doing insane things. Are there to rescue us. Saviour theory, I think, is misconceived. It misunderstands the constitution. It's not consistent with comity, I think. Misunderstands the relationship, the balance that should hold between them. Where parliamentary accountability is a real thing, electoral accountability is real. They do constrain. Now, they don't constrain in a way that means, well, we can just abolish judicial review and proceed as though it wasn't a relevant part of the constitutional machinery. Of course not. The constraint on government to follow the law is a vital constraint. I may disagree with Alison on the declaratory point. I think it's not just a requirement of comity, it's a requirement of law. If the law is declared, this is what the law is, then the government should faithfully fall into line with it. I mean, it may propose legislation to change it, but that's a different matter. Now, defanging the courts. Defanging is a sort of way of framing this that makes it look like the technique of a pseudo-dictator or elected dictator, looking to crush sites of opposition. But the courts shouldn't be a site of political opposition. They should be a site where you can vindicate your legal rights and insist on legal powers being observed. And any approach, any legislative technique that stopped the courts doing their traditional role, including in the vast range of cases that don't involve judicial review, would be highly problematic, wildly controversial, and should be opposed. But to look at some of what goes on in judicial review and think some of this gives rise to a problematic type of litigation that's compensating for, attempting to compensate for parliamentary accountability, and that should be corrected. I think that's perfectly consistent with the constitution of a parliamentary democracy. You can argue about the details, of course, we can argue about them all day long, but it's a mistake to parody that as a proposal to abolish the law, the rule of law. It's simply not.
Thank you for that. The elephant in the room that's not been mentioned is, of course, why can't we have elected courts?
Okay, shall I start with that?
Yeah, go ahead.
Elected judges would be terrible at being judges. They wouldn't be very good at independently applying the law to the cases before them, including cases involving the parties in question. There's a reason we have independent judges and have had for centuries, and it's something to treasure, namely that they are protected and elevated and given the status and the confidence and salary and all these protections, so that when they hit a case, including a hard case with popular people or unpopular ones, they won't decide with a view to currying favour later. They will apply the law as it stands and not be distracted from it. And thank God.
Does anyone else want to say anything on that?
On elected courts, no,
Yeah.
but on elective dictatorship, yes. If
Go
I
ahead, and keep speaking into the microphone.
Okay, I don't necessarily think you can say elective dictatorship. I think you have to think very carefully about it. But I don't also think you can say that the political constitution is itself perfect. I think you have to think very, very carefully about how we elect governments, what our voting system is, what the internal rules of Parliament is, and how far the government can, if it wishes, control the parliamentary timetable, meaning there isn't necessarily a huge amount of time to debate issues. This means things can be missed. Should the courts go in and automatically correct outcomes? No. But should the courts be there to perform their own proper constitutional role? Yes. And I think maybe we should be thinking in terms of political reform if we want to deal with elected dictatorships rather than judicial reform.
Thank you. What I'm going to do, there's one last question, which I do not want you to apply your legal skills to in interring or disaggregating it, but I think the question will be pretty clear. And then I'll give you a chance if any of you want to say anything in case you feel you've not had a fair opportunity. The question's from Armina Lunat, and it says, should Parliament be granted extended sovereignty when the Tory government is currently unable to account for its own crimes, like the parties held at Number 10? In other words, should Parliament step in and sort all of this out? And this was one of the most popular questions that has come in. And because I've been sitting here, I don't know whether what's happened on Partygate this morning, but we know that 20 tickets were going to be issued today. Jonathan, do you want to go first?
Oh, thanks. Maybe yes and no is the answer. So we have a legal process that is now underway, and like you, I don't know where it's got to enforce the law as it stands, as enacted by Parliament and by ministers under powers conferred by Parliament, and that should be allowed to run its course. I don't think Parliament should step in and try and interfere with that. Because there is a legal process and the police are onto it, and if there are fines, then they should be subject to the legal process that applies to that, and so on. So I don't think Parliament should step in and try and interfere with that. When all that is done, whatever the outcome may be, does Parliament have a role in holding the government and ultimately the Prime Minister to account for what went on in Downing Street, whatever it was? Undoubtedly, yes. And that is political accountability for the conduct of government and the conduct at the heart of government. So that's I'll stop there because I've answered the question no and yes.
Stephen.
Well, yeah, I want to give a relatively limited answer to this too, but I think I broadly agree with Jonathan. I think parliamentary accountability and the political constitution does work. I think if abstract politicians are found to have broken the law in a way that the public disapprove of, they will pay a political price for it. And that is the way that the political constitution works. And I don't think the law needs to go interfere with that end of the process. Obviously, whether or not there is a breach of the law is going to be a matter for the courts. But enforcing it against politicians or restraining the powers of Parliament because you think politicians are out of control, I think is misconceived. I found a quote I was trying to find earlier on, which is, it's from lots of people actually, but it's Machiavelli warned us almost 500 years ago not to be fooled into thinking that calmness and solemnity are the mark of a good polity and noise and conflict a symptom of political pathology. Just because there's a row doesn't mean that the answer to it is going to be decided in the wrong way.
Thank you, Alison.
Nothing much to add, really. If they've committed a criminal offence, then you use the law, and yes, they should be accountable to Parliament. I don't think that means extending the sovereignty of Parliament. That's precisely what parliamentary sovereignty is there for, to hold the government to account for its actions, as well as to enact legislation.
I agree with everything my colleagues have said, except Alison's last tiny remark. No, exactly. So I don't think it's a question of parliamentary sovereignty. It's a question of parliamentary accountability, political accountability. And the government will be quite rightly hauled over coals by Parliament and the public. And we'll see how that plays out.
Thank you. Does anyone else want to say anything that they've not had a chance to say? In which case, our timing is perfect. We've just brought the session to an end within the time frame allowed. I would like to remind you that the next session follows straight on from this one, which is a natural sequitur: can and should Parliament take back control from the executive? Now, I imagine some of you who've been here since 9 o'clock this morning are thinking, my God, where's the coffee break? In fact, because there is so much rich and wonderful material, there is no coffee break, but don't panic, because there's coffee downstairs, so if you want to nip out and grab yourself a cup of coffee and come back, please feel free. I suggest you do it not all at once, because otherwise we'll have a de facto coffee break and you'll lose lunch. But there is coffee ready downstairs if you are desperate. Now, before I close, I want to thank incredibly warmly the wonderful panellists for giving of their time, their expertise, and also their disagreement. As you can see, lawyers, contrary to popular belief, are not a homogenous group who have one view on all matters, that they are very different, and these are really vexed questions. Thank you so much, all of you, for giving of your time. Thank you very much indeed.